Okay. I'm Melissa, and I'm going to be discussing abortion for my Women in U.S. History project. Abortion in the United States and abortion-related issues are the subject of intense public and political debate and discussion in the U.S. Various anti-abortion laws have been in place since 1900 in some way. However, abortion was prohibited in 30 states and legal under certain circumstances, such as pregnancies resulting from rape or incest in 20 states. The Supreme Court's 1973 decision of Roe versus Wade instituted all of these laws and set better guidelines in notion to support abortion. Roe established that abortion must be considered against improvement, state interest in regulation, as stated from my internet source. The case established trimesters, which corresponded in the likelihood of survival outside the uterus over the course of a pregnancy. States were prohibited from banning abortion early in pregnancy, but allowed to impose increasing restrictions of outright bans later in pregnancy. The decision was then changed in the 1992 case Planned Parenthood versus Casey, which upheld the main fields of Roe by replacing the trimester system with the point of fetal viability whenever that occurs. Casey also lowered the legal standard of states upholding women's rights and sticking with the legal rights, even if they conflicted with one another. Roe had held this to be strict scrutiny, the traditional Supreme Court test for impositions upon fundamental constitutional rights, where Casey created a new standard referring to a new burden, specifically to balance the states and the women's interests in the case of abortion. Even with all the changes made by both Supreme Court cases, abortion remains one of the most controversial issues in the U.S. culturally and politically. The main issues are most often labeled either as pro-choice or pro-life. There are different stages of these two issues, and most Americans are somewhere in the middle. The pro-choice position was most popular in the early to mid 1990s, which is a drastic change from the 1970s and 1980s. Although pro-choice was popular in the early to mid 1990s, things soon changed. In 1995, the U.S. House of Representatives and U.S. Senate tried numerous times to pass measures banning the procedure of intact dilation and extraculation, also commonly known as primal birth abortion, as stated from the sources. After several long and emotional debates on this issue, such measures passed twice by wide margins. Those and were voted on in April 1996 and October 1997, although they did not pass. On October 2nd, 2003, with a vote of 281 to 142, the House again approved a measure banning the procedure called the Partial Birth Abortion Ban Act. Throughout this legislation, a doctor could face up to 2 years in jail and lawsuits for performing an abortion in this way. A woman who undergoes this procedure cannot be prosecuted against. However, it can be done if the woman's life is in danger. The Supreme Court upheld the nationwide ban on the procedure in the case Gonzalez versus Carhart on April 18, 2007, signaling a substantial change in the court's approach to abortion law. The current judicial interpretation of the U.S. Constitution regarding abortion in the U.S. is that abortion is legal, but may have some restrictions in certain states. In some states, they result late-term abortion require parental notification for minors and mandate the disclosure of abortion risk information to patients prior to the procedure. One part of the legal abortion regimen today is determining when the fetus is viable outside the womb as a measure of when the life of the fetus is its own. And in the majority opinion delivered by the court of Roe versus Wade, viability was defined as being able to live outside of the mother's womb. Viability is usually placed at about 7 months, but may occur earlier. Requirements to qualify for an abortion vary from state to state. Currently, California, Oregon, Montana, Vermont, and New Hampshire allow qualified non-physician health professionals, such as physicians, assistants, nurse practitioners, and certified nurse midwives to do first trimester abortions and prescribe drugs for medical abortions. Additionally, Washington State, New Mexico, Illinois, Maryland, New York, and Massachusetts, Connecticut, and New Jersey allow qualified non-physicians to prescribe drugs for medical abortions. Only in all other states, only licensed physicians may perform abortions. With that, I would like to conclude my report, and I hope you enjoyed it.